Good morning, everybody. Welcome to the Courtroom Files Live. Happy Wednesday. Let's start our day in Michigan with Judge Shackelford.
Call the third a second. But I know that the circuit court does have authority to sentence people to district court, sobriety court, and I'm hoping that the fact of already being in it will be an incentive to the circuit court to do that.
Well, I know that Miss Bonarotti clearly needs a treatment court program. I mean, that's clear, and she's been honest about it. So I'm optimistic that you'll find your way back to me on that one as well. Okay? All right, ma'am, you understand this is tough, right?
Yes, ma'am.
And did you already meet with Miss Wagman this morning, or are you doing it after? Okay. So for bond conditions, this is a lot. You understand that?
Yes.
No drugs or alcohol. You'll random drug test as directed on Navy. You'll have a scram tether for 90 days, and that'll be followed by random PVD testings on Fuchsia. You'll attend pro-social meetings 3 times a week as directed by probation officer, and you'll provide proof. You'll enroll in and complete treatment as directed. You'll report to probation officer weekly or as directed. You'll report to treatment court status hearings as directed. You cannot operate a motor vehicle without a valid license. You cannot enter areas known for drug or alcohol use. You can't surround yourself with drug or alcohol using peers. You're not to enter establishments where the primary purpose of the business is the sale or service of alcohol. You're to obtain a temporary sponsor or mentor within 30 days and a permanent within 60 days. You'll receive a consultation for medically assisted treatment. You'll attend the alumni group while you're in orientation in phase 1. You'll enroll in peer recovery services at GrowthWorks as directed. You'll attend 10 Northwest fan meetings while in orientation, phase 1, phase 2, or phase 3. Can you come to the women's group?
Yes, she should be able to.
Okay. You understand all those conditions?
Yes, Your Honor.
All right, that's a lot. And I mean, I have a little concern. I see where you're working, and that's a place you're not allowed to go.
Yes, ma'am.
So, I have some concerns about that. And I think you should start venturing out and looking for other employment. I'm not going to tell you right this minute to go quit your job,
Okay.
but you need to look elsewhere. Like seriously look elsewhere.
Okay.
That's your drug of choice, and it's not a good idea, especially considering all of your circumstances right now and what you have going on at circuit. You do not want, you're looking for grace.
Right.
And a way to not get grace is to work at one of the few places you're not allowed to be.
Yes.
So I would be actively, like today, trying to find alternative employment. I think I'm not just telling you this as a judge, I'm telling you this as a human. That's not going to bode well for you downtown.
Okay.
Okay?
Yes, ma'am.
All right. Anything else?
No, ma'am.
That's it, Your Honor.
All right, Ms. Bonarotti, welcome to the program. I think you'll actually, I don't know that anyone enjoys coming to court, but I think once you get the swing of things, you'll see a lot of benefits.
Yes, I'm definitely looking forward to it.
Well, I'm happy to have you.
Thank you.
Yep, we'll see you soon.
Thanks, Your Honor. Have a nice day.
You too, thank you. Aaron, I want to talk to you about that file. Remind me by the end of the day. I want to have a conversation with you. Okay. All right, we're all set. This is 2429760M, the City of Taylor versus Ali Schauman.
Morning, Your Honor. Jeffrey Fanto on behalf of Mr. Spellman. Trying to get the complaint.
Mr. Schauman, you need to turn your camera on.
Okay. Good morning.
Morning. Let's see. Looks like the check-in room's trying to.
Yeah, and Matt's in there talking to him. We're just keeping this on track for trial on the 9th, Judge.
Okay.
Everybody. And I've advised Mr. Zick.
Okay, so it looks like we're going to jury trial on this case. It's set for jury trial next Friday.
Yes, the 9th.
May 9th. And I'm at a mandatory conference. Mr. Fanto, just so you know, it'll be Judge Salamone.
Okay, thank you.
Okay?
Yep.
All right, we'll see, bond continues, we'll see everyone at trial, everyone is to appear in person at the 23rd District Court, and you must be here by 9 a.m.
Thank you, Your Honor.
Thank you, Judge.
All right, we're all set, everyone have a good day, we'll see you back on the trial date.
You're all set,
Thank you.
Mr. Shulman. See you Saturday.
Thank you, sir.
Mr. Bazo and Mr. Ibrahim, you can also log off and we'll be talking.
Thank you.
We could leave, right?
You can, Mr. Bazo.
You can leave.
Yep.
Let's head over to Judge McNally's court, a little bit up the road, and say good morning to him.
So go out in the hallway and he'll set you up. He'll take this to the prosecutor. Best of luck. People against Courtney Ann Louise Collins, 25W838-336. Could I also have Carlton Thomas Johnson up here, please? Carlton Johnson, 25W838-349. Ma'am, your name. Come on up, sir.
Courtney Collins.
Right next to her, state your name, please.
Carlton Johnson.
Each of you have the right to a lawyer. You're both charged with suspended driving. If you want one, I'll give you one. Do you want one, Ms. Collins?
Yes.
You want one, Mr. Johnson? Ms. Collins, you can go out and I'll set you up with a lawyer. And then you'll either way come back in front of me. Mr. Johnson, you can,
You want me to leave?
no, I don't want you to do anything except go out in the hallway and my court officer's gonna set you up with a lawyer, okay? All right, now, Mr. Johnson, you're charged with operating a motor vehicle with suspended license. They think you were driving in the city of Woodhaven, County of Wayne on April the 4th of 25 in the city of Woodhaven on I-75 near Breland at 2:50 p.m. on that date. That is a misdemeanor, punishable by 500 fines, 93 days jail, costs, or all those in 2 points. Do you understand that?
Yes, sir.
And did you sign, read, and understand an advice of rights form today? You got to keep your voice up for me. If you
Yes,
plead
sir.
guilty, you'll be giving up all those rights. I need a good pen. And there will be no hearing or trial. Do you understand that?
Yes, sir.
All right, you still wish to waive your right to a lawyer?
Yes, sir.
I'm gonna enter a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. You're gonna go ahead and you're going to go out in the hallway. He's gonna take your file to the prosecutor. If the prosecutor doesn't offer you what you want, then you can request a court-appointed lawyer at that time, okay?
Yes, sir.
I wish you well. Good luck to you, sir.
Judge Fleischer is off to an early start since we didn't spend any time with him yesterday. Let's say good morning.
And probable cause to go forward with your case. I'm ordering you not to go back to this gas station. Do you understand?
Sir.
You're on felony deferred for a very serious case, and now you've picked up a new case. When you're on felony probation, you're to live as if you have a halo above your. You understand?
Yes, sir.
What gas station is this, please?
This is the 7-Eleven gas station located at 17010 Highway 59.
Don't go back.
Gotcha.
Do you mind filing those conditions, please?
Yes, Your Honor.
I'll appoint you a lawyer today, Mr. Hawkins, but I don't want any more issues. You become a danger to my city. It's not going to go well for you. You need to imagine that if you don't have anyone else to bond you out, you will be stuck like Chuck in there. Do you understand?
Yes.
All right. I'll have you sign a reset with Victoria, and I'm going to have you take a seat in the jury box while I find your lawyer, sir. Do not leave until you sign our bond condition.
Next judge is page 21, Rodriguez. Come on up.
Rodriguez, already?
Yes.
Yes.
Good morning, Mr. Rodriguez. Sir, you're charged with terroristic threat of a family or household member. That makes it a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 22nd, 2025, in Harris County, Texas, law enforcement officers were dispatched to a family disturbance call. Law enforcement officers made contact with the complaining witness, who was the defendant's wife for 15 years. The law enforcement officers could hear the defendant yelling inside of the house. Law enforcement officers detained the defendant. The complaining witness stated she was shoved by the defendant and fell on a chair, and that the defendant then stated he was going to punch her with his fist, and that he was punching his own hand in a threatening manner. A witness, the defendant's son-in-law, stated he heard the defendant threaten the complaining witness and saw the defendant punching his own hand in a threatening manner.
What was again?
The threat, the defendant then stated he was going to punch her with his fist and that he was punching his own hand in a threatening manner.
Mr. Rodriguez, I'm going to find that there's sufficient probable cause to go forward with your case. I see that we have a prior assault from 2024 and 2 prior VPOs, and I'm trying to see if they're all with the same complaining witness. I see the assault is the same complaining witness. 1 VPO is
Can I speak?
no, it's not the time.
Judge, we can see on our end, they are all the same claims.
Okay. Mr. Rodriguez, I want you to understand something and let me make it clear to you. I'm going to protect every person in my county. I don't care who they are, what color they are, if they're a small farm animal. I will protect every single person. And if you become a danger to my community, I only have one place for you. Do you understand me?
Yes, sir.
I don't want you to have any contact with the complaining witness in this case, and I'm gonna put a monitor on you so I know where you are. I don't want you to go within 1,000 feet of where she lives or where she works. Do you understand?
She's my boss. She hired me. I work with her. She's the GM.
I don't care what's going on. All I want is my city protected. And
Yes,
the
sir.
idea is that I don't want you to have any kind of run-ins with her. You guys have words and then something drastic happens. And I'm trying to prevent
Yes, sir.
something nuclear from going down. The best way to do that is to keep you guys away from each other. Do you understand?
Yes, sir.
If you have cancer, you cut it out. Otherwise, it kills you. Sometimes in your life, you have people who are a cancer to you. And if you don't cut it out, you end up in custody with a very main sentence. This is now your 5th case regarding the same person. Do you catch my drift?
Yes, sir.
All right. Do you have the ability to hire a lawyer?
No, sir.
I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. I also don't want you to be in possession of weapons.
No, I don't have no
If you qualify, I'll give you a lawyer today. But I'm telling you now, I don't know who you have in this world. But if I find that you're a danger and I have to make your bond $10,000, $15,000, $30,000,
Yes, sir.
you don't have anyone to pony you up, you'll be stuck like Chuck. You understand?
Yes, sir.
Come on.
All right, Judge, next, page 26, Williams, come on up.
Good morning, Mr. Williams.
Good morning.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 22nd, 2025, in Harris County, Texas, law enforcement officers observed a motor vehicle with no front license plate. A traffic stop was conducted. Law enforcement officers made contact with the defendant and observed a strong odor of marijuana. The defendant stated to law enforcement officers that he has a handgun in the vehicle. The defendant admitted to having smoked marijuana in the car previously. The law enforcement officers located the marijuana and a handgun inside of the defendant's motor vehicle. The marijuana weighed approximately 55.7 grams.
Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with your case. You mind running his license, please? I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand?
Yes, sir.
If you do not have a license and liability insurance in your name, you're not allowed to drive, and that is also a bond condition of yours. Do you have the ability to hire a lawyer?
Yes, sir.
We're going to give you time. I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go.
All right.
Don't pick up any new cases.
Yes, sir.
Your Honor, his license is eligible.
Great. Okay, please. So do you mind finding those conditions, please?
Yes, Your Honor.
Sign for your reset. Judge, this last one, I have a case number for you.
Okay.
2561239. This one was an arraignment from yesterday that fell to here. It's
Okay.
here today.
Ms. Joya, come up. Why did you miss court, ma'am? Sorry? When you don't come to court, we issue a warrant and you end up going to jail. I'm going to reinstate your bond, but I'm not going to do this again. The next time you miss court and I have to issue a warrant, you will go to jail. Do you understand me? No more get out of jail free cards. This is it. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one, ma'am. Okay.
Thank you, Your Honor. On April 21st, 2025, in Harris County, Texas, law enforcement officers were dispatched to a shoplifting call at JCPenney and made contact with the complaining witness, a loss prevention officer. The complaining witness stated the defendant entered the store and placed 2 swimsuit sets in a black purse, then passed all points of sale and exited the store. The total value of the merchandise was $144.
This is the co-defendant to yesterday's theft, right?
That's correct, yes.
Okay. Ms. Joy, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go back to JCPenney and not to be in contact with the co-defendant in this case. Do you understand? What do you do for a living? Did you graduate from high school? I'm sending you now for a drug test. I want to know if anything is in your system and you're to come right back. You're 18 and you have nowhere headed. That's not a good way to go through life. You know, you should never, ever have to depend on anyone, and you need to be a strong person to be able to work and make money. Because in this life, if you don't have money, this life sucks. And you're 18 and you're headed nowhere where you're going to end up being dependent on someone. That's not a way to go through life. You need to get into school, get knowledge so you have a good job, so you can support yourself, so you don't have to rely on anyone, much less a man. Men suck. Don't rely on them. Be a strong woman. You understand? Okay, I'm sending you for a drug test. You're to come right back, and I'm going to appoint your lawyer today. Just take a seat for a minute.
Can I get her to sign real quick?
Yeah.
Deputy, here. Sign for me, sir. Judge, that was the last one for now.
Okay. Mr. Moody.
Yes, Your Honor.
Good morning, sir.
Good morning, Your Honor.
Who do you have?
I have Chun Feng Yan, and Your Honor, she is in ICE custody. I'm having somebody email a copy of the document to the court clerk, and I have it here as well.
What? Send it to Victoria. Let me give you her email address. Do you have it or no?
I have it, Judge. Let me
Yeah, send it to
redirect.
Victoria. That way it'll be easier that way.
Yes, Your Honor, I'll do that right now.
So she's in ICE custody now?
She is, Judge, yes.
What's going on with that? Do you have a hearing set or do you have a bond set?
Your Honor, it's my understanding that she is going to go back to her country, which is China. So there is no bond, and there is no parole, and there is no, as of yet, I don't know if there's a hearing still pending, because it was my understanding that she was going to be agreeing to return.
When do you know when that's going to happen? Because we should get her back here to try to take care of this first, shouldn't we?
If Your Honor, if that's possible, yes. I can reach out to the immigration lawyer and see if I can find that out.
So what I'm going to do then is I'm going to issue a bench warrant today to try to get her back.
Yes, Your Honor.
So we can try to take care of it, because sending her, having her go back and having this still open, I'm going to end up issuing a warrant, because I just can't keep it open forever. And then
Yes,
it'll
sir.
impact her chances of if she ever wants to try to come back.
Yes, Your Honor, of course. Oh, you did? Oh, okay.
Give me 1 second, Mr. Moody.
Yes, Your Honor.
Page 27. She's in ICE custody. We need to bench warrant her to try to get her before. Looks like she signed for a voluntary departure, but we need to get her back to try to take care of this before.
Okay.
So, all right, we're going to bench warrant her, and then we'll reach out to you when we get her.
Yes, Your Honor. If it pleases the court, I can try and reach that immigration lawyer now, if Your Honor would like me to.
How's May 19th as a reset?
Yes, Judge, let me. May 19th, Your Honor. Yes, Your Honor. Yes,
Is
thank
that
you.
okay?
Yes, Judge.
Okay, we'll put it on that day then.
Thank you, Judge.
And we'll see you then. If we get her before then, we'll let you know.
Yes, Your Honor. Thank you.
Okay. Thanks, man.
Thank you, sir.
Fun.
So he's got a little bit of a quieter courtroom this morning. Let's do something a little different for the channel, because I haven't visited this judge before. Let's go to Lenawee County, Michigan. This is Anna Marie Anzalone. And let's say good morning to her.
Issue a bench warrant for Miss Walden and set bond in the amount of $25,000 cash.
Thank you, Your Honor.
Thank you, Miss Underwood. All right, Mr. Simmons, that's all I have with Mr. Goldstein, so why don't I take you next? In the matter of the people of the state of Michigan versus Emmanuel Simmons, we have 1, 2, 3 files, 24-21830FH and 24-22051FH and 24-22052FH. I have David Goldstein appearing on behalf of Mr. Simmons and Isaac Sneed appearing on behalf of the people. Mr. Simmons and Mr. Goldstein, I have a note dated April 29th from Darren Coast, our pretrial services coordinator, who states that Mr. Simmons continues to do a good job with his testing. He does not miss. He's only positive for THC and has a medical marijuana card. So, Mr. Goldstein, how would you like to proceed today on behalf of Mr. Simmons?
Your Honor, I'm going to ask that these matters be set for trial. I suspect the trial date's going to be a ways out, which leaves Mr. Sneed and I plenty of time to continue discussing possible resolution.
All right, so would these be tried together or would they be?
They're separate incidents as far as I can tell, Your Honor.
Okay, so we would start with trial on.
Your Honor, if I could propose, if we could set the trial on the file ending 30FH, that's my case. The other two are Mr. McCready's. And so.
Okay, that's the oldest one anyway, so that's the one I would set for trial first.
Is that the 7/16/24, Isaac?
No, 21830.
No, I'm
Right,
looking at the date.
Isaac.
I'm looking at the date, Your Honor.
Oh, I'm looking at file numbers. I'm sorry.
Yeah, one moment, I can look up the date. Yeah, it's Valentine's Day of 2024.
Yeah, okay. I never get this. When there's multiple files, I get the numbers mixed up, so.
So Mr. Sneed, we would do 21830 first.
Yes, please.
Okay. Hold on one second. All right. That is assault with intent and ag domestic violence. So how many days do you think you need for trial, Mr. Goldstein?
Believe 2, Your Honor.
Does that include jury deliberations?
Yes, Your Honor.
Mr. Sneed?
I would agree with that, Your Honor.
All right. Yeah, so that's a good thing. Tuesday, September 2nd.
Just a moment, Your Honor. Oh, I'm looking at the wrong month. Hang on, Your Honor. I already have a jury trial scheduled for that week, Your Honor. I can do the next week.
Yeah, your retirement's going really well, Mr. Goldstein.
I'm trying, Your Honor.
How about Wednesday, September 10?
That would work.
Mr. Sneed?
Yes, thank you, Your Honor.
All right.
And then my suggestion, Your Honor, would be to put the other 2 cases on for pretrial that morning.
Yep, they will, and then I'll have them all set for the final pretrial. So the Wednesday trial day would start at 10:30 a.m. and then it would be a 9 a.m. start date on Thursday and into Friday, if we go that far. And then let's see, so do September 10. I want to do a final pretrial on, let's see, you're in trial. Would you be able to do a pretrial on September 3rd or no?
Probably not, Your Honor. It's going to be an ugly trial, so.
August 27th?
I'm going to be, just a second. August 27th. Yeah, that should work.
All right, I'll set a final pretrial for all files on August 27 at 8:30 in the morning. That'll be the motion deadline, just to make it clean. And I require all jury instructions and voir dire questions to be provided to the court on, let's see, August 20th, just so we have time to review them for the final pretrial. And I think that is it. So I filled out a scheduling order and we will get a copy of that out. Keep up with your bond conditions, Mr. Simmons, you're doing a good job. And then I will see you all back for those dates. Obviously, if you reach a resolution, Mr. Goldstein, I'm always happy to take it on a day that's not a Wednesday.
Thank you, Your Honor.
All right, thank you all. Your bond's continued, sir.
So while she's between people, kind good morning once again to everybody. Welcome to the Courtroom Files Live. It is Wednesday. I don't know about all of you, but I had a hard time getting going this morning. I did not want to move, but I did because I love joining you guys. So here we are. Once again, this is Anna Marie Anzalone. She is a judge in Lenawee County, Michigan. First time we visited her here on the channel. We'll stick with her for a few more minutes and then see what else is going on.
Ms. Wise is going to handle that this morning, Your Honor.
Great. And where's your client?
She is outside.
You can, okay, bring her in. Thank you. All right. Hey, this is Judge Anzalone. I'm ready for like everybody on my list.
Okay, tell you what time we'll start with Howard.
No, Powers is set at 10 o'clock today.
Oh.
So the rest of them. Okay, thank you.
Right.
Bye.
And I stand corrected for the record, Anzalone. I would have said Anzalone, but she knows her name better than I do.
All right, Mr. Glazier, I'm gonna go ahead and mute you. All right, okay, Mr. McKenzie, let's see. I'll take care of you while they're having a discussion here. So in the matter of the people of the state of Michigan versus Casey McKenzie, file number 24-21789FH. Mr. McKenzie, we are here for a pretrial on your file. You are currently pro per. Did you request court appointed counsel, Mr. McKenzie?
Court appointed.
All right, so did you, you have Mr. Fry, correct?
Yes.
Okay, so we are waiting on Mr. Fry. And so if you don't mind, just be patient with us while we wait for him to get here, all right?
All right, thank you.
All right, thank you. And are you ready on Henderson now?
We are, Your Honor.
Okay, let me find her file. All right, this is in the matter of the people of the state of Michigan versus Caitlin Elaine Wise Roberson. Is it Robertson or Roberson? Robertson. All right, you can stand up here next to Mr. Margolis. I have Larry Margolis appearing on behalf of Ms. Wise Roberson, and I have Jacqueline Wise appearing on behalf of people. I'm assuming there's no relation. No. Okay. And so this is a date and time set for a pretrial. So Mr. Margolis, how would you like to proceed today?
Thank you, Judge. Nice seeing you. Good morning.
Good to see you too.
I'm here on behalf of Ms. Caitlin Wise Roberson. I've spoken at length with the office of the prosecutor, first with Mr. Hartung and now with Ms. Wise, and we are prepared to put a plea on the record.
All right. And so what is the plea offer?
So we will be pleading to count one. I'll let Ms. Wise first state the recitation on her understanding, and then I will confirm if that's okay with Your Honor.
Ms. Wise?
Yes, Your Honor. I believe Ms. Roberson will be pleading guilty as charged. There is a restitution amount. We discussed that we believe there was an amount embezzled of approximately $241,000. However, we would both reserve the right to have a restitution hearing once that PSI is done. We would be requesting no upfront jail to allow Ms. Roberson the opportunity to pay those funds back. We would be asking for probation for a term of 5 years, again, to pay those funds back. Upon successful completion of payment of that restitution to Glove Enterprises, the people would move to then reduce the felony to a misdemeanor. If that is successfully completed and there are no new cases during that 5-year probation and she successfully completes that. Am I missing anything, Mr. Margolis?
I don't believe so. Is that your understanding? That's our understanding. We're prepared to move forward. We have brought the first payment today, the down payment of $10,000 certified funds that I have provided to the dutiful prosecutor.
And I am in receipt of those funds, Your Honor.
You're going to keep those, right? You're not going to give them to me? Thank you. Okay. All right. Yes.
Where is this on the docket?
It was handwritten in. I apologize. So your docket might have it on the bottom of page 1.
Okay.
So do you want the file number?
Please.
24-22022 FH, and her name is Caitlin with 2 I's, right? And Wise hyphenated Roberson. Okay. So you're gonna have to bear with me because I've been really sick, so I can't breathe. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, so you're gonna need to speak a little bit louder.
Yes, Your Honor.
Okay, so, and you go by Weiss Roberson or?
Weiss
Yes.
Roberson.
Okay, you can put your hand down. So you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, embezzlement, $100,000 or more, which carries a maximum a penalty of up to 20 years in prison and or a fine up to $50,000 or 3 times the amount embezzled, which is ever greater. Do you understand that?
Yes, Your Honor.
All right, and there is an agreement that restitution is thought to be around 241,000. Each party has a right to have a hearing on the amount. There will be no upfront jail, 5 years probation, and
So sorry.
if it's paid in full by the end of probation, this would be reduced to a misdemeanor. Do you understand that?
Yes, Your Honor.
Now, you understand if you were to violate probation or not make payments, you could potentially go to jail or prison. Do you understand that?
Yes.
Okay. Now, are you satisfied with Mr. Margolis as your attorney and the advice that he's given you?
Yes, Your Honor.
All right. And other than that, neither the prosecutor, the defendant, or anyone on the defendant's behalf has made or discussed any other possible sentence with the court. Mr. Margolis?
That's correct.
That's correct.
Ms. Weiss? Okay. And is that correct as far as you're aware?
Yes.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. You have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right. So, ma'am, how do you wish to plead to the charge that on or about March 27 of 2024 in the city of Tecumseh in the county of Lenawee, that you did commit the offense of embezzlement, 100,000 or more, guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
I understand.
Okay, sure you want me to go over that again? You got it?
I got it.
Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Margolis?
No, Judge.
And Ms. Weiss?
No, Your Honor, just for clarification, though, the date should have been from sometime in 2020 through 2024. So I apologize for that. It was a date.
Do we know those dates?
No, I don't. You have that in front of you. I can,
It was early 2020 through early first quarter of 2020.
I just now realized that the date was wrong, so I'll pull that up if you want, and then when we go over the factual basis, I'll do it. Thank you.
All right.
On or about February 2020 through February of 2024.
Yes, Your Honor, thank you.
So, Ms. Weiss Robertson, would you agree with that?
Yes.
Okay. Let's see, has your attorney promised you, other than the agreement that was placed on the record, any particular sentence or estimated sentence will be in terms of fines and costs and probation terms?
No.
Okay. Is it your own choice to plead guilty?
Yes.
All right. So, during February of 2020 through February of 2024, is that what we're going with?
Yes.
All right. Were you employed at, is it Glove Enterprises?
Yes.
And what was your position there?
Controller and HR manager.
So, did you have, I don't know, Ms. Weiss or Mr. Margolis, you want to blend here on this?
Did you Sure, I will, Judge, if that's okay. In that capacity as controller, did you have access to the checkbook?
Yes.
Did you have access, were you able to write those checks
Yes.
for the company?
Yes.
And did you write checks to yourself?
Yes.
And were you authorized to write certain checks to yourself?
No.
And you did?
Yes.
Okay. And it was your intent to defraud the company of that monies? You were converting it to your own use, were you not?
Yes.
All right, so that could be defrauding the company?
Yes.
Ms. Wise, any follow-up?
And it had a value of at least over $100,000, correct? Yes.
You understand that you and your attorney have a right to a restitution hearing if you want one?
Yes.
Okay. Are you satisfied, Ms. Wise?
Yes, Your Honor.
We are, Judge.
All right, I accept, has the court complied with MCR 6.302 B, C, and D? Mr. Margolis?
You have, Judge.
Ms. Weiss?
Yes, Your Honor.
All right, and I accept the plea. It's been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew agreement that was placed upon the record. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Margolis, sentencing can be done in person or via Zoom unless the prosecutor has a preference. Are you available June 12th at 8:15?
I believe so. If not, I will let the court know.
I mean, yeah, I can wait.
No, it sounds like I'm in town. That'd be the only reason I wouldn't. That's fine, Judge. If something were to change, I'll let the court know.
Oh, of course, we can. So, do you want to appear in person or via Zoom?
As of now, let's appear in person.
In person, okay. All right, so that's gonna be at 8:15 in the morning. So this morning, Mr. Margolis will walk you across the hall to the probation department. Check in there, they're gonna give you instructions on meeting with them. When you meet with them for the pre-sentence report, be truthful with them about your background, the events that occurred. They'll prepare a report. We will send that to Mr. Margolis. He'll review that with you before sentencing, and we will see you back on June 12th at 8:15 in the morning in person, okay? Anything else, Ms. Weiss?
No, Your Honor.
Mr.
Thank you.
Margolis?
Restitution hearing would be after.
Yeah, if you dispute it, we can always adjourn the sentencing to do the restitution hearing if we need to. It's not a problem.
Thank you.
Thank
All
you,
right,
Judge.
thank you both, and just step across the hall, please.
Always a pleasure.
Always a pleasure, thank you.
Joanne?
I think I
So if I heard that right, obviously she hasn't actually been sentenced yet, but the proposed deal here was that she goes on probation, and at the end of the probation, if she's paid off the $243,000, I believe it was, in restitution, it gets reduced to a misdemeanor. That's if that's true and that's what she actually grants, that's some crazy good work by the defense attorney there, because wow, to embezzle $250,000 and possibly end up with a misdemeanor at the end is something. Let's change it up a little bit. Judge Fleischer's court is still incredibly quiet. They need to just install Fortnite on his computer, I think, at the bench for these kind of days. Let's go back to Judge McNally.
That would, in my opinion, violate the no contact provision using a third party to have contact. So the people do have concern about it.
He sent that to who?
The victim. He texted the victim's girlfriend's daughter to tell the victim to come out and let's deal with this, quote unquote, as a man.
Did you do that?
Hold on a second. Your Honor, can we have a minute? I mean, I should have known this before I came in. There was these allegations, something supposedly happened. And they are allegations. So can we recall this? I can talk to the prosecutor.
Yeah,
This shouldn't even been said on the record.
Hang on.
Stop.
Hang on a second. Just relax. Why couldn't the victim stick around for a few minutes? I mean,
Judge, he was really concerned about missing work. If he did not want to
do
address.
you have his phone number?
I'll have Lieutenant Tolan.
I mean, this is quite a serious allegation. So can you try to get his phone number and see if he can at least zoom in? I mean, I was ready to go at 8:30. If somebody would have told me this was ready, I would have been glad to come out here. I mean,
Was that Senator?
yeah, so let's pass this and
Give me a hold.
thank you. Thank you. Recalling Brandon Persinger. 23R 720609. All right, your name?
I'm like to know.
He pled guilty. He did the 10 hours of community service by December 7th. I mean, not by December 7th, but since then. I'm sorry.
Yes, he submitted a letter or 2 letters to me this week. He completed, April 28th, he did 8 hours for Focus Hope, and he did another 2 hours and 15 minutes at Victory Gym. That letter is dated April 25th.
Look. Okay. Why don't you? I want to be so understanding here with you. But you didn't get around to doing something for 3.5 months. You've not done anything on your fines. I want to be understanding on that.
And Judge, we were working with him for some health stuff, which he did provide documentation.
I know.
We had to light a fire to I had to schedule this for him to get them done.
The fines getting laid off work is what stopped me for fines. But I'm finally caught up, but I just told her starting this week, I'll be paying enough to be caught up and paid off by October, November.
Why did you miss this court work program?
Honestly, I got told about it so long ago that I completely forgot. I try setting the thing on the calendar on my phone, and every time I set one, I don't know if I'm doing it wrong, but it don't notify me. I have to set an alarm clock and for that day. So we rescheduled that. I asked Emily if she would send me a reminder email like a week before it, so I know for sure I can make that one.
Say that again?
I asked Emily if she would give me a heads up like a week or 2 before, because we rescheduled it to make sure I make it, because I tried setting it in my calendar and it don't go off on my phone. If you go deep into my phone, I try setting I want to set something up for August and I'll put it on the calendar in Google, it don't make my phone go off. But I suck with technology. Last time I used
I'm not very good at it either, but I can put that in my phone. You gotta be more responsible. I mean, I don't know what to tell you. I don't know what to do with him. I mean, he deserves to go to jail and I don't want to send him to jail, so we gotta figure out something else. So I'm thinking, if you can't pay your fines, you're gonna have to do community service. Now, you just told me you're gonna start to pay next week?
No, this week, Thursday.
Tomorrow's Thursday.
Yeah.
How much can you pay per week?
I told Emily 100 a week, and she said if you pay 60 something, 67 or 66, that I'll be paid off for firm off probation.
I think that's what I figured out for him to have it paid off. But he graduated.
All right,
It would be paid off November.
you pay 70 per week beginning. I'll start it Monday, okay?
Okay.
That's the
If I
5th.
pay it this week, does that count?
Pardon me?
If I pay it this week, that's.
You're gonna start to pay it on May the 5th. You pay 70 per week. I'm not gonna assess any additional costs. I'm not gonna do anything else. But Brandon, you're worrying me. You really are. I mean, I want you to get through this program. I want you to stay clean.
Been on that side, it's just walking everywhere and
I get it.
trying to make places on time.
I get it. I understand. That's why I'm doing this. You're trying. I get it. All right, 70 a week, beginning May the 5th. Reschedule the court work.
We already did.
If I pay tomorrow or Friday, does that count as a full?
Yeah, you just pay 70 every Monday, but you don't have, if just stay ahead of it if you want to.
Okay.
You can pay tomorrow, you can pay whenever you want, but 70 a week, starting on Monday. If you paid it tomorrow, you don't have to pay again until the 20th. If you don't have the money, you need to come talk to me though. Do we understand one another?
Yes, sir.
Or you call Mr. Casino and we'll go on Zoom and I'll give you an extension. But you can't continue to ignore everything. If I need to have you do community service in lieu of payment of fines, I will do that. Okay?
Okay.
All right,
Can I ask one question?
sure.
He was eligible for phased advancement February 28th. Technically, the rule is he has to have 90 days clean, which he does. Are you okay with me phase advancing the next one now that the community service is done, or would you like me to wait, or?
It's not just clean, it's no violation.
Well, it's a major violation.
Yeah, I'm not gonna consider these major violations. I'll advance you. Listen to me. You gotta stay with this,
Yes, sir.
okay? Go ahead.
Thank you.
Stay with me, Brandon. I want you to get through the program, okay?
Oh, yeah, sure. I'll make you a copy.
That's good.
Okay, let's change it up yet again. Let's go back to Lenawee County, but instead of Judge Anzalone, this is Judge Olsaver.
No problem. This is file 24-21832-FH, People versus Christina Marie Sanford. And I'm sorry, Ms. Underwood, that all happened while you were in a breakout session. Were you able to finish that?
No, we were through with our breakout session, Your Honor.
Okay. So we are here today for a hearing on an alleged violation of probation. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Ms. Sanford this morning, Your Honor.
And Ms. Sanford is present from the jail. Ms. Underwood, do you know how Ms. Sanford would like to proceed
Ms.
today?
Sanford is going to plead guilty to the violation this morning. I have reviewed Mr. McCarron's recommendation with her, Your Honor. She is aware of all of its facets, and she's going to plead guilty to the violation this morning, Your Honor.
Okay. Ms. Sanford, would you raise your right hand, please? Do you swear or affirm? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I swear to tell the truth, the whole truth, and nothing but the truth.
All right, and you are Christina Sanford, is that correct?
Yes, Your Honor.
You can put your hand down if you want. Ms. Sanford, do you understand that you have a right to contest the violation of probation charge and to have a trial on it?
Yes, I do.
And you also had a contempt of court for failing to appear at the original probation violation hearing. Do you understand that you have a right to contest that contempt of court and have a trial on that as well?
Yes, Your Honor, and I never received any paperwork in the mail for that. That's the only reason I didn't receive for that, but I'm just supposed to move forward with it.
Okay. Do you understand that with respect to the probation violation, that throughout any trial, you would be presumed innocent until your guilt is proven by a preponderance of evidence?
Can you say that again? I wasn't really sure what you meant by that.
Do you understand that if we had a trial on the probation violation, that you would be presumed innocent until your guilt was proven by a preponderance of evidence?
How does that work, Rhonda? I'm not.
It means that more evidence than not. They would have to prove more evidence than not that you were guilty. It's not beyond a reasonable doubt. It's a preponderance. That's just over 50%.
I'm not sure. I think I'm better
Okay,
just go.
so do you understand, Ms. Sanford, that if we had a trial, we would start with the presumption that you were innocent?
Right.
Okay, and then we would have the trial and evidence would be submitted. And in order to find you guilty of the probation violation, I would have to find that it was more likely than not that you in fact committed the violation.
So how do you think that would work, Rhonda? I mean,
He would hear evidence.
I've
and he
never
would
done
be-
it, anything like that. So is that a good way to go? Or for what I'm being dealt with right now?
Well,
Maybe Ms.
What
Underwood, I
is
should
it?
put you back in maybe I should put you back in a breakout session with Ms. Sanford.
Sorry, I just never had anything like that before, so I'm not really familiar with that.
Sorry, everybody. Looks like he finished up. I was looking at 5 different feeds at the time. Lots going on. Let's just go across the hall for a minute. Oh no. Well, I don't know what's going on there. Are they finished? Somebody tell me real quick in the chat. Again, apologies. I had my eyes on like 5 other things. No, they're coming back. I'm not sure what's going on.
Ms. Sanford wants to proceed.
Ms. Sanford would like to continue the plea, Your Honor.
Okay.
Okay.
I think I'm
so
listening.
Ms. Sanford, do you understand now that again, that throughout any trial, you would be presumed innocent until your guilt was proven by a preponderance of evidence?
Yes, Your Honor.
And with respect to the failure to appear, you would have the same presumption of innocence, but in that situation, your guilt would have to be proven beyond a reasonable doubt.
Yes, Your Honor.
You would have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses that you might have for your defense to appear at your trial. Do you understand all of that?
Yes, Your Honor.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, Your Honor.
On the other hand, you would have the right to testify at the trial if you wanted to testify. Do you understand that as well?
Yes, Your Honor.
How do you want to plead then to the charge that you violated your probation?
Guilty.
And how do you want to plead to the charge that you failed to appear in court?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, Your Honor.
Has anything been promised to you in order to get you to plead guilty?
No, Your Honor.
Have you been threatened in any way in order to get you to plead guilty?
No, Your Honor.
If I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice? I'm sorry.
The only thing I may ask is, what address is on my record? So, because I didn't get anything in the mail for the court's not showing up for the court, so I just want to make sure I have the right address.
I'm sorry, it's difficult to understand what you're saying due to the echo in the room. Can you sit a little closer to the microphone?
I just want to make sure I have the right address on record because I never received anything saying I had a court appearance. I just want to make sure I have one. The right address. Should be 511 Logan Street.
Oh, no, wait. I don't want you to say your address right now. Give me a second.
Oh, sorry.
Well, now he's clearly done. I wasn't sure earlier. Apologies. Sometimes there's so much going on, I lose track of what I'm actually showing you guys, and I have to catch up. Let's head about an hour to the northeast. We'll go to Detroit. Judge Bryant is online, which does not happen every day with her. So let's say good morning.
Assault or assault battery. Today is the day set for an arraignment. Appearances, please. Mr. Skoronsky, you better start your camera.
Good morning, Your Honor. Alex Hill on behalf of the people.
Good morning, Your Honor. Ivan Land, P65879, appearing on behalf of Ms. King, who's present on the screen, Your Honor. We have no objection to holding these proceedings by Zoom. Thank you.
All right, and Ms. King, state your name, unmute. Unmute.
Ivory King.
And what's your middle name?
Arjuna.
Thank you. Mr. Land, how you wish to proceed?
For arraignment purposes, Your Honor, we stand mute and wait the formal reading. We just asked for a pretrial date, and I would like to have the discovery sent to me as well.
Court is going to continue, enter and not guilty. Please set the matter for pretrial conference. Counsel, if you waive your client's right to have a pretrial conference within 14 days, then the court can order the and have the complaining witness present.
Yes, Your Honor.
Then the court will set the matter for pretrial conference. June 10th, if that's a good day for you.
It is, Your Honor.
June 10th at 8:25, discovery should be submitted to the defense no later than May 15th. And then the complaining witness is required to appear at the pretrial conference. As to bond, Mr. Land.
Your Honor, my client turned herself in when she received a notification. We made arrangements with the court. We just asked for a $500 personal bond in this matter. Thank you.
Any do the people wish to be heard?
No, Your Honor, we bond the discretion of the court.
All right, court sets bond in the amount of $1,000 personal bond, no contact with complaining witness. Anything further?
No, by the people, thank you.
I'm for the defendant, Your Honor.
All right, then you're all set. Have a great day. Stay safe. I'm ready on surround.
Thanks so much. Always a pleasure, Your Honor. Take care.
All right, thank you. All right, what's that?
I like Judge Bryant because she can be fun to watch, but her court is also often very disorganized, so it'll probably take her a little bit to find the next person. Let's go back to Judge Anzalone. Something about Lenawee County this morning. They're busy. A lot of the courts this morning, quite honestly, are not busy. There's a lot of courts that are in session, just not a lot going on. So let's go back to Judge Anzalone.
So, you guys can chat if you want an update. I'm not giving breakout rooms for AGs, prosecutors, and attorneys. So Oscar Hernandez Ramirez, oh, you're right there. Come on up. He's present in person. You know, you can appear via Zoom if you need to, right? Yeah. Okay. So this is in the matter of the people of the state of Michigan versus Oscar Hernandez Ramirez. Just because you look like you were supposed to be at work. Yeah, so you can Zoom from your vehicle if you want. You don't have to come in person.
Okay.
Okay, I don't want you to miss work. 24-219-65FH. This is a date and time set for pretrial. Again, I have Ms. Williams appearing on behalf of the AG's office and Ms. Underwood on behalf of the defendant. So Ms. Underwood, how would you like to proceed today?
First of all, I apologize, Your Honor, because since I don't know which AG is appearing, I can't check. And so that was why the breakout was requested. But, Your Honor, I would like to ask for probably a 90-day adjournment in this matter. Mr. Ramirez Hernandez has been excellent at making his payments, and I don't suspect that has stopped. In addition, he has appeared this morning, and he's kind of been a really good example since he made his bond.
All right, Ms. Williams, do you want to verify that?
Yes, I have verified. He has been paying consistently
Although this month, I'm not sure why it was a couple dollars short than the monthly obligation amount, but he has been paying consistently. I would agree with that. I guess I would just need to know or clarify from Ms. Underwood what we're seeking with the adjournment. Are you trying to get a reduction in?
We're trying to work towards some sort of delay plea.
Oh, okay. I have no objection to that.
All right, well, where do you work at?
Yeah.
Oh, okay. So, yeah. Do you need an interpreter?
No, I'm good.
You're good? All right. So Miss Underwood or Miss Adams, can I get a pretrial notice for June 18? He's going to be hitting his busy season now, so he might be able to pay extra. And then Miss Adams, could I get a Zoom instruction for him as well? So we will set this for June 19. And I'll do the notice just because he's here and I want to make sure he gets one when he leaves at 8:30 in the morning. And if you Zoom, you can just go sit in the car and call in. All right. That way you don't miss work.
Mr. Hernandez Ramirez, could you contact my office with a good phone number? We do not have one for you.
John, wanna?
I can do that.
No. Mr. Steers, you're all set.
Yeah.
Okay. You're all set.
All right, so the 21st.
Yes, sir. I think
Okay,
so.
thank you.
So have a seat right behind you. Have a seat, and then we'll get you a notice. All right. Thank you.
Thank you.
All right, and I believe Miss Williams, that gets you on your way. Thank you.
Thank you. Bye.
Okay, so
I think
I
that's
got Brian
everything
Fro-
for me, Your Honor. Or
Heimerdinger.
Hmm?
So you have a Heimerdinger, Heimer.
Oh,
Heimerdinger.
yeah. Is she on the screen from Jackson?
So let me pull the file. I think I already set a warrant to catch her, but this is in the matter of the people of the state of Michigan versus Jamie Marie Heimerdinger, file number 21-204 07FH. Let's see, April 2nd. I still have a warrant for her so that we get a hold, but I don't see that she has appeared. Do we have any contact with Jackson for today?
Thank you.
All right, thank you.
Thank you.
All right, let us just check, but I've already issued a warrant for her. She has not appeared, so I believe we're all set.
She appeared the last time from Jackson.
I know, but I still left a warrant in for a holder, so I don't lose her. All right, Miss Adams is gonna check if we still do. Okay, Mr. Fry, I have
Judge.
Casey. Yes.
Yes, they responded that they would have her available.
So she's not available yet, but if we get her, I'll call you.
Okay, thank you.
All right, thanks, Miss Underwood. All right, Mr. McKenzie, I'm gonna see if I didn't screw that up by, I'm asking for an unmute. I don't, oh, yes, you can do it. Perfect.
Let's go over to Judge Fleischer. He actually has a contestant.
Stolen from her front porch. Mr. Green, I'm going to find that there's probable cause to go forward with your case. I'm now sending you for a drug test. I want to know what, if anything, is in your system, and you're to come right back. Do you understand? Right. Do you understand? I'm also going to put a GPS monitor on your ankle, and I'm ordering you not to go anywhere near this apartment complex. If I find that you do, if I find that you're a weapon, that you have a weapon, if I find that you're a danger to my community, I will revoke your bond, and I'm going to make it sky high. You are on felony deferred for a very serious case. Does he have a felony warrant? Why is this showing no bond?
I'm not sure, Judge, but I don't see it.
Take a seat for me. We'll have you sent in see you in 15 minutes, 20 minutes.
If they had set it no bond under this version, the motion, and then they dismissed it and put them back on probation. And they went to ISA back in October.
Know anything?
Did you tell me to appoint?
Not yet.
No, okay.
And just that quickly as court is quiet again, let's go back to Judge Anzalone.
Probation judge and an arraignment.
Yep, so in the matter of the people of the state of Michigan versus Ricardo Anthony Garcia, I have two files set for probation violation 21-20525FH and 21-20575FC. I have two files set for arraignment today, 25-22232FH and 25-22233FH. I have Salvatore Milaro appearing on all of these files, and I have Isaac Sneed appearing on behalf of the people. So, he's on parole and probation, I think. He's on parole with Mr. Face and probation with Ms. Teskey. So, Mr. Milaro, do you waive the reading of the information on the arraignment files?
Yes, Judge, at this time, we'd waive reading of the information, waive any defects as to time and place of service. Mr. Garcia would stand mute as to all of the counts and the habitual offender notices in both files. We would ask that the court enter a not guilty plea. We'd further acknowledge receipt of the witness list and ask that these matters be set for pretrial. And we'd also ask that the violations of probations also be set for pretrial at the same time. Judge, we're close to having this resolved. We're just waiting on, I think Mr. Garcia was referred for recovery court, waiting on that decision.
May 21.
That's fine. And I did talk to Mr. Face. I think that part of his case is kind of resolvable.
What do you need?
DQ on a file or send it down here.
Oh, yeah. What is it?
There, Evans, CART Evans.
Okay.
Should be the court.
Okay, Joanne needs to file next thing. Am I doing it today?
Yes.
Oh, yeah, give it to Joanne first. Thank you, Serge.
Yes, ma'am.
All right, so I'm gonna enter a plea of not guilty on all the files. I'm gonna set a pretrial conference for May 21 at 8:30 in the morning. And is there anything else that's continued? Anything else, Mr. Millar or Mr. Sneed or Ms. Walsh?
No, thank you.
Not at this time,
All right.
Judge. Thank you.
All right, Mr. Garcia, thank you very much. We'll see you back on May 21. And Mr. Milaro, we do the notices on all those, so you don't have to do anything today. Thank you.
Thank you, Judge.
All right, so Brian's talking to Casey McKenzie, and I have Joseph Brown. Miss Adams, I have a PPO file that's being added today. If you need the information. Alright.
I guess I can give the file number just in case.
20, I already gave it to Ms. Spade, 25-52438 PP.
Thank you.
So Mr. Brown, your attorney is Mr. Milaro. So in the matter of the people of the state of Michigan versus Joseph Brian Brown, file number 24-22087FH. Salvatore, Douglas Hartung appearing on behalf of the people, and Salvatore Milaro appearing on behalf of Mr. Brown. This is the date and time set for a pretrial conference. Mr. Milaro, how would you like to proceed? I can't hear you.
Can you hear me now, Judge?
Yeah, oh yeah, I can hear you now.
Your Honor, I would ask to adjourn this one time. I need to sit down with Mr. Hartung and see if this matter can be resolved short of trial.
Your Honor, I have no objection to that. I do want to indicate on the record, this is exactly the position of the defense at the last pretrial. So
I'm happy to sit down with Sam anytime he wants to talk about it.
All right, May 14 at 8:30 in the morning.
That's fine, Judge.
Hold on one second, please. Is it possible to do it the following week?
Yep. May 21 at 8:30 in the morning.
Does that work, Mr. Malaro?
That works, Judge. And Mr. Hartung.
Thank you.
All right, and Mr. Malaro, you do this in order to adjourn. Will you do this in order to adjourn?
Yes, I will do that for you, Judge.
You can find my name if you'd like to.
Obviously, if there's a resolution sooner, just let us know and I'll bring them in. All right?
Thank you.
All right, Mr. Brown, I'll see you back then, if not sooner, okay?
Yes, ma'am.
All right, so, let's see. Are you a defendant? What's your last name? Evans? Oh, you're that new PPO file, got it. All right, you're gonna have a seat. Are you a defendant? What's your last name?
Hey, did we did an exam on Casey McKenzie? Did we ever get a copy of that, you know?
Oh, no.
I don't know if we did it be in the file. The prelim?
Yeah.
Yeah, it's in there.
Okay.
Mr. Malaro,
if it is,
I have.
can you send it to
Mr.
Brian?
Malaro, you're not muted? Okay, Ms. Fonseca, why don't you step up? We'll get rid of, not get rid of you, but take care of you while you're here today. All right. All right, Mr. Malaro, when you're ready, I have Ms. Fonseca here.
So some ghosts in the machine this morning. While all of this was going on in Judge Anzalone's court, my quote-unquote big board where I monitor all of the various courtrooms just went out. I've got it back powered up, but I can't get stuff onto it. So we're going to soldier on. We might do a little less switching around than normal because it's going to limit the amount of courts I can monitor at once. But for me to troubleshoot it would probably mean a need to stop the stream, which I'm not going to do. So we'll make the best. Let's go over to Judge Washington's court. She's been very busy this morning, but we haven't visited there yet.
It would be a violation. I will put you in a breakout room so you can talk to him.
Thank you, Your Honor.
I'll pass that matter. The court will call the case of Ypsilanti Township versus Nabil Ahmad, case number 24T00472.
Paul Barnett on behalf of the township.
Nabil Ahmad.
Thank you. Good morning, Mr.
Sorry, my Zoom, like when you open up the video now for the last couple of weeks, like it just won't open, but I'm here. Sam Bernstein for Mr. Ahmad, who introduced himself.
Thank you. We're here for sentencing in this matter, and Mr. Ahmad did keep his appointment.
Yes.
He completed his appointment and he did the Med Victims Impact Panel already, Your Honor, as well. He can get that certificate to probation outside of court. We've read the recommendation. A couple of comments, Your Honor. Part of the recommendation calls for no marijuana. Mr. Ahmad does have a medical marijuana card. He has had it since 2022, probably a couple of months ago at this point. We submitted letters to the court. I don't know if the court has those readily available, but he has a doctor-patient relationship with a doctor. It's been ongoing since 2022 with periodic visits every couple of months to work on a medical necessity problem that's outlined in the letters. And the doctor also lists, he seems to be a very well-qualified physician who has very well thought out views on what he's doing. So there does seem to be a lot of medical necessity as well as a real doctor-patient relationship. It's not a, I hate to say it, but like a situation where someone gets a card like 3 days after they're arraigned or something like that. You know, he's been doing this, you know, for a while. He also, a part of the recommendation, and so we would ask essentially that he be able to continue to use medical marijuana. I know, you know, looking at the report that marijuana was present in his system. I would also note that he was like a 0.07 at the time too. And so while I was charged as operating under the presence of controlled substance, it seems, I would suggest and I would guess based on his admissions to being inexperienced with alcohol to Mr. Statman that 0.07 was probably a factor here as well in the bad driving. He also, the recommendation does have him not being allowed to be in people in possession of it. Nabil also works at like a marijuana facility, and he has worked there for a long time. It's a 40-hour-a-week job, and that's like his profession and what he does. So we would hope that he'd be able to continue working there. As far as what the court wants him to do while on probation, I mean, I don't, you know, it looks like the probation recommended like an AA meeting a week. You know, I don't know how much benefit exactly he'll get from that. You know, I think it's pretty clear he's not an alcoholic. I mean, he made a bad decision to drive while under the influence, certainly, but you know, I don't know if the problem's exactly there to be fixed with an AA meeting a week. Perhaps more like early intervention, like counseling and like educational programming and abstinence from alcohol and community service might be just better tailored for who he is. I know he's been testing regularly while on probation or on bond. He's had no problems abstaining from alcohol during that time. So that's what I would expect, like on a probationary period. But we're hoping the court takes those things into account. I know there's been a pretty impactful like process for him. I've spoken with him, I've spoken with his family, and it's, you know, been a scary experience in a sense. And I know he could probably say it better than me, but you know, it hasn't been lost on him that he drove in a dangerous manner, and he's been upset about that ever since, and he's been appropriately, you know, scared since then, Your Honor. So we're hoping the court takes, you know, the factors I've been saying into consideration in making its recommendation, or sorry, its sentence.
Thank you. Mr. Barnett?
Your Honor, I've also reviewed the pre-sentence investigative report and the recommendations. I support the recommendations. As it relates to the marijuana, I mean, as counsel correctly points out, this is a case that involved the presence of marijuana in his system, along with alcohol. So that's a concern, and I think it's appropriately reflected in the recommendations, and I support those.
Thank you. Mr. It's a hyphenated name, is that correct, Jawad Ahmad?
You can call me Mr. Ahmad.
Thank you, Mr. Ahmad. Is there anything you would like to say, sir?
Yes. This whole experience since that first night, definitely it's been an impact on my life. I'd never really pictured myself to be in a situation like this. I've never had, you know, I come from a family that's very religious. We don't drink. Even like me having marijuana is a big deal to them in the first place. But liquor, I was never going after that, you know. That one night was my first time really experimenting with it, and I made a bad decision. Spent the night in jail, and since that night, I've been dealing with the repercussions of the decision I made that night, and I will never make that decision ever again.
Thank you for that, sir. There's a big ask today to give you an opportunity to continue to use marijuana in light of the fact that you were using it and alcohol and deciding to drive. And I understand. You're telling me you made a decision that night and the consequences have been pretty dire for you. I get that. But they could have been much worse for another individual. And that's always what this court is concerned about. Among, your safety and other things. But I read the letters that came from your doctor and your head situation is concerning for me. And one of the stronger letters I've seen with respect to why it is necessary for you to use. But the court is not obligated to give you that because you were violating the Medical Marijuana Act. So legally, I don't have to give you that opportunity. And I'm still weighing that. I do like that you take this seriously, and I think you do, that the repercussions for you have been so, I guess, powerful that it may have made that difference for you. I'm going to continue to think about it until I get to the end of my sentence and decide what I'm going to do about that. It is the sentence of this court that you serve 93 days in the Washtenaw County Jail, credit for 1 day served. The balance of that is suspended, so you won't have to do any additional jail time if you do what you're ordered to do. Okay.
Yes.
You're to complete a total of 5 days for a total of 40 hours of community service. You're on probation for 9 months. You'll be eligible for early discharge if you complete all the terms within the first half of that time, so after 4.5 months. Fines and court costs. Mr. Bernstein, are you appointed or retained?
I was retained, Your Honor.
Okay. Fines and court costs in this particular case for a total of $1,295, $30 per month probation oversight fee. You are to report to the probation officer monthly via the online reporting platform during the second week of each month. You're to complete an outpatient assessment with Don Firm within 14 days of this sentence and sign a release of information. Complete the MAV victim impact panel within 45 days. I understand you've already done that, so just provide those proofs. No use or possession of firearm components, ammunition, or other than dangerous weapons, no possession of alcohol, illegal drugs, paraphernalia, and no being in the presence of anyone using those. You'll have an exception for being in the presence of people with marijuana because of your job. You must drug and alcohol test 2 times per month and any other times it's ordered by the court, probation, or police. You either attend NA 1 time per week and provide probation with proof of that. You're going to have a review in front of me on July 30th, 2025, and that's going to be at 10 o'clock a.m. As for the medical marijuana, can I see counsel in a breakout room, please?
All right, she's going to go to a breakout room. Link, you see what evidence they have that he was high while driving. Well, that's part of the problem with the legalization of marijuana in a lot of these states is there's no good standards on how to test, what to look for as far as levels go. There's nothing. It's just one big gray area nobody really knows how to deal with. So there you go. Let's she might be gone for a little while, so let's go over to Judge McNally. By the way, the ghost in the machine, it vanished all of a sudden while we were listening to Judge Washington. My big board just fully came back with all the feeds and everything. I have no idea. It's a weird Wednesday.
And that night, I've added additional stress to my wife and my family. I'm taking this very seriously, sir, and as Mr. Warren said, I do not plan on seeing you in this courtroom again.
Well, I'm really sorry about your wife. I hope everything works out. Well, The only thing I can tell you is if you get another one of these in your life, it's a felony. You know that, right?
Yes,
Then your life, as you know it, is over.
yes.
It is nice, however, to see somebody remorseful, and I truly believe you're sincere with this. So 15 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, your home telephone number, you must notify probation. You have to report as directed. By the way, has he shown you the AA verification? I just want to make sure he's been going twice a week since April 10th. So there should be at least 5 or 6 on there.
There's April 19th, 20th, and 27th. There's 2 on the 27th, or the 29th. See one yesterday. That's a 7. That's a 7. Okay. There are 4 entries, Your Honor.
No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You submit to chemical testing, PBTs and ETGs. And I'm going to make that as follows. I'm gonna make it bi-weekly testing for 2 months. Well, for 3 months, for 3 months. If you're clean, I'll then make it monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You do have to remain on the SoberLink device until July 1st, okay? I want you going to AA, NA at least twice a week until you're in treatment. You have to go to outpatient treatment. Once you get in outpatient treatment, you don't have to do AA or NA or any other 12-step program. So if you get in outpatient this week, you don't have to go to AA or NA any longer. You're to attend the Victims Impact Panel, which is one night put on by Mothers Against Drunk Drivers, okay?
Thank you, Your Honor.
I'm going to submit to you that, remind me, counsel, this was a breathalyzer, right? Not a blood draw?
Correct. It was,
So it's $150 in cost of recovery. I cap it at 2 1/4 on the blood and 150 on the breath. $300 in fines, 200 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs here amount to 6 1/4. You have probation fees of $300 for 9 1/4. You have cost of recovery of $150 for a total of $1,075. You have a screening fee of $60 for $1,135. For $1,135, and then you have 4 days jail, I'm sorry, 5 days jail credit 1. I'm gonna let you serve 3 of those on the court work program. There's a $105 charge for that, $35 a day. And I'm gonna let you do 8 more hours of community service by, I'll give you all the way until July 1st to complete that. So 8 hours of community service by July 1, 3 days on the court work program. And, should be $1,240 on the fines. If you violate probation, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Now listen, I'm cutting you a break here, okay? No more of this, all right? You may be eligible for early discharge. If you get everything done after 7.5 months, you can come in here and request early termination of your probation. You are a lucky man right now. Do you understand? I'm buying this because I understand it's sickening what you're going through at that age. But you got to use your brains. You were driving on Rose Lane thinking you were on Boxford, right? Right?
yes.
Okay. So I'm cutting you a massive break here. Do not tempt me by not complying with probation 100%. Do we understand one another?
100% understanding, Your Honor.
Okay. Can you pay all this today or does he need time, Mr. Dory?
I can pay it all today.
I wish you well, and I wish your wife well. I really do.
Thank you, Your Honor.
Good luck to you.
Thank you. Thank you, Your Honor.
Thanks, Mr. Willie.
Have a nice day.
You too. You'll meet with probation after you make your payment here, okay? Best of luck, young man. And good luck to you, ma'am. Are we ready on the bow yet or not? Did they come back in? All right, people against Sanders, Brianne Rachel Sanders, 25W837958. Your name? All right, Ms. Sanders, you're charged with violation of parental responsibility law, saying you failed to assure the regular attendance of your son Cyrus Helcom at Bates Elementary on Goodith near Weston, Woodhaven. They wrote this April the 4th. You have the right to a lawyer. I'll be happy to provide you with one today at public expense if you would like one. I'm sorry?
No, thank you.
You waive your right to a lawyer?
Yes.
So this is a misdemeanor. They think you didn't send your child to school. It is punishable by up to 500 fines, 90 days jail, costs are all three of those. Do you understand that, ma'am?
Yes, I did.
I'm sorry?
I did.
Did you sign the advice of rights?
Yes, I did.
Did you read it and understand it?
I did.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial of any kind. You understand that?
I did.
All right. You still wish to waive your right to a lawyer?
I did.
Enter a not guilty plea for you. I'm going to give you a personal bond of $500. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Your child is to attend school with no unexcused absences. I'm giving you a personal bond. I'm going to let you go and talk to the prosecutor, see if you can work it out. If you can't, either way, you're coming back in front of me, okay? So $500 personal bond, I'm entering a not guilty plea. He'll take you to the Woodhaven city attorney and you can talk to him, okay? And then either way, you're coming back in front of me. Do you understand everything? All right, good luck. Thank you. Harvey.
For the hundreds and hundreds of hours of court that I've watched over the last 7 months, I have not seen anybody in front of a judge for a truancy type of issue like that. Something new every day.
All right, so we're gonna adjourn this for you, okay?
Yes.
I'm gonna give you, we'll take it out 4 weeks or thereabouts, Lisa.
May 28th at 8:30.
Okay, May the 28th at 8:30 in the morning, you can go down the hall and you will get your court date, okay?
Thank you.
Best of luck. And I'm entering a plea of denial, by the way, on the other file, this civil infraction. So that will take place on the same day. Eckert, Luke Michael Eckert, 25W838357, Mr. Eckert, your name.
Okay.
You're charged with assault and battery. You have the right to a lawyer. Do you want a lawyer? I'm sorry?
No, sir.
All right, so on April 5 of 25, it is alleged that you did at 7:30 p.m. at 22114 Reinhardt in Woodhaven, physically assaulted, batter the victim by the name of Brady. That is a misdemeanor, punishable by up to 500 fines, 90 days jail. Costs or all of those penalties. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a trial or a hearing. Do you understand
Yes,
that?
sir.
All right, do you still wish to waive your right to a lawyer?
I don't want to.
You
I
waive
don't
your,
want a lawyer.
so you still wish to waive your right to
Oh,
a,
yes, sir. No.
I'm sorry?
Yes, sir.
I'm entering a not guilty plea. I'm giving you a $1,000 personal bond. So you don't have to post any money. But I want you to listen carefully. These are your bond conditions. No contact with the victim, Brady. No contact with prosecution witnesses except through your lawyer. You're not to possess firearms. You're not to possess dangerous weapons. You're not to leave the state without the consent of the court or violate a law. You must appear in court as directed. You do have to go over to the Woodhaven Police Department to be fingerprinted and photographed by noon today. Do you understand that?
Yes, sir.
We're going to give you an order in that regard. All right? We're going to give you an order for prints. We're going to give you a copy of the bond sheet. And you can take all that over to Woodhaven, give them the order for prints, and they will print you today. Do you understand that?
Okay, yes, sir.
But I will let you go talk to the prosecutor now. So you're going to go talk with the prosecutor, but no matter what happens in there, whether it's adjourned or there's a plea, you have to go over to Brownstown, to Woodhaven rather, by noon today. And you have to get fingerprinted and photographed, and these bond conditions will be with you. You cannot possess firearms or dangerous weapons. Again, no contact with the prosecution witnesses, no contact with the victim, and again, you have to, as a condition of your bond, go over there and get printed. But before that, we will send you to the Woodhaven prosecutor, and you will talk to him. Either way, you're coming back in front of me today. Do you understand that?
Yes, sir.
Okay. We'll see you in a few.
Okay. So see you all.
So Bailey, if the state requires that a child go to school, would it be less of a right and more of a requirement? Just saying. And yeah, I mean, truancy is a thing. You've all called out a few cases that I haven't personally seen it come up in a court that I've monitored before. And I have a totally different take on it. So I have 3 children from my first marriage. They're all adults now. They all went through the public school system. Mrs. the Courtroom Files and I, we have a son who is approaching 17. We have homeschooled him since day one. And in our opinion, anyways, it's made all the difference. This kid is so intelligent and so well balanced. It's unreal. So, I mean, truancy isn't a thing that we deal with. He rolls out of bed and he's in school. But anyways, back to court.
Get moving on your license, okay? You understand?
Yes, sir.
All right, so I'll give you until May the 28th, Lisa, at what time?
8:45.
Listen, you got warrants all over the place here. You got one in Monroe, one in Redford, another in Redford. So I shouldn't say, you've got 3. Go take care of those as well. Go down the hall, get your notice, May 28th at 8:45. We'll see you back here. Any questions?
No, sir.
All right, good luck. Are they ready on this LeBeau case, or what are they doing? Just find out what if he got a hold of the victim or not.
Yep.
Good. Judge,
Yes.
Mr. Schulman has a bond violation today on Flamont,
Yeah.
and he's stuck in a murder trial. Can he come tomorrow?
Jeez.
That's what the secretary just called to tell me.
Where's Flamont at? Is Flamont coming today? Where's Flamont?
I'm assuming he is, unless he told him not to.
I don't care. He can come tomorrow, but he's got to notify his client to be here.
Oh, I'm sorry. Hold on. I'm reading her message. It says he's currently in a murder trial today and Thursday.
All right.
Yeah, Kazman, funding is tied to attendance pretty much everywhere, not just Texas. It's a thing. That's why they have like 2 times a year where it's like a big deal if you're sick that day. The school will freak out because that's when the official attendance is taken for their funding. So it looks like he's pretty much cleared out his courtroom. There is a big lull in the action. I'm going to go back to Judge Anzalone because honestly, she's one of the few that's got things going at the moment. There's a couple of trials going on, but it makes no sense to go there because they're longer ones, so we wouldn't catch anything that would have any kind of context. A bunch of courts in recess. Judge Fleischer has been away from the bench for a good half an hour now, so he's obviously just sleeping or something. It's so dead there. But yeah, let's go to Judge Anzalone.
Yes, ma'am.
And on that day you assaulted her, so did you push her, pull her, punch her, kick her? What did you do to assault her on that day?
Push her again.
Okay, all right. Mr. Sneed, are you satisfied?
Yes, we'll accept that plea. Thanks.
All right. Has court complied with MCR 6.302 B, C, and D? Mr. Glazier
Yes, it has.
and Mr. Steen?
Yes, thank you.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor's office, the defendant, the defense attorney, or anyone acting in the interest of either of them. I'm going to refer this matter to the district court probation department for a pre-sentence investigation. Mr. Glazier, are you available June 12 at 8:15 in the morning for sentencing?
Yes, Your Honor.
All right, and Mr. Orozco, do you want to appear in person or via Zoom?
Zoom.
Zoom, okay. All right, Mr. Glazier will meet with you in advance of sentencing. Someone from district court will come and meet with you and do a pre-sentence report. We'll provide that to Mr. Glazier and he'll meet with you before sentencing day, and we will be truthful with them about your background, the events that occurred, and we'll see you back on June 12 at 8:15 in the morning via Zoom. So you're all set, Mr. Orozco. Thank you.
Ma'am, even though I'm seeing district probation, I'm going to be in your court though?
Yep, so it's a misdemeanor plea, so I keep it for sentencing. And are you on probation upstairs anymore?
No.
Good. All right. Yep, I do the sentencing, not district court, okay?
All right.
Thank you. And Mr. Glazier, just to make sure it's on everybody's radar, May 1, starting on May 1, if defendants violate bond conditions or terms of agreement before sentencing, they will no longer have the right to withdraw a plea. Under Killebrew, there's been a change in the law and it starts May 1. So we'll start changing. They have to, like, if they violate bond conditions or commit a new offense or violate a plea agreement, they won't have, I think, that automatic right to a plea withdrawal.
Okay.
So I know we sent an email out about it, so I just want to make sure it's on everybody's radar starting next week.
All right. Thank you, Your Honor.
You're welcome. All right, you're all set, Mr. Orozco and Mr. Glazier. I don't think I have anything else with you.
That's all I have. Thank you, Your Honor.
All right, thank you. All right, Mr. Orozco, you're all set.
Thank you.
And Isaac, I think we sent that over to the prosecutor too. I'm not sure. We could probably resend it though.
Yeah, we got it, Judge.
Okay. I think it's what if they violate bond conditions, violate plea agreement conditions, or commit a new offense, even if there's a Killebrew or Cobbs, they won't have the right to withdraw the plea. I thought that's what it basically was. So
Yeah.
okay. I have a couple left. I have Charity Smith. I don't have her, but I have Matthew Powers at 10:30. And then Heimerdinger. Ms. Adams, were we able to verify whether Jackson was going to produce her?
I have not reached out to him. I will, Judge.
So, all right, I do have a PPO file I received from Judge Olsaver. So, is it Zaret? You want to come sit here, please? And then Mr. Evans, you'll come sit there. This is in the matter of Zaret Evans versus Dustin Evans, file number 25-52438 PP. This is previously a Judge Olsaver file and he is disqualifying. So we have been brought this file this morning. So, and how do you pronounce your first name?
Zaret.
Zaret? Yes. All right, I'm gonna put that in here. Just make sure you speak loudly for us. So can both of you raise your right hands for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Ms. Evans?
Yes,
And Mr. Evans?
ma'am.
You're gonna have to, I know you're soft spoken, but you gotta speak loud for me, okay?
Yes, Your Honor.
Okay, so, this is a date and time set for a show cause. I showed that on February 21, I actually signed a PPO in this case. I don't know why it was down in Judge Saber's file, but it was. And this personal protection order remains in effect to August 22nd of this year. I typically do that. Was a divorce filed as well?
Yes, Your Honor.
Okay, so I typically do that 6-month cooling off period because that's usually when the first pretrial, you must have minor children.
Yes, Your Honor.
Okay, so I set it out and then Ms. Evans filed a motion to show cause for violation of the personal protection order back on April 18th of 2025. And she stated that the respondent violated the PPO. On April 18th, you left your residence at military time, is that 2:11 in the morning?
Yes, Your Honor.
Okay, to head to your work site for your Marine Corps Martial Arts Program final training event. You left the children home with your mother. You made it there around 3:45 a.m. and at 3:57, you said he called you and texted you, fuck the legal stuff, right after not answering his phone call. He then decided to go to the house and saw that your car wasn't home. He accused you of leaving the children alone and said he's looking for our son Noah. That at 4:20 a.m. he broke into the house through the living room door. My mother was upstairs, she didn't hear anything. And he entered the house and was with your son Noah. He texted you, you had the police dispatched. You did call him to see if he took Noah, but Noah answered the phone. And then he was at your house on the phone. So let me ask you this. The divorce case was filed. Did you have, okay. So he's continued to text you and to call you. Is that correct?
Yes, Your Honor.
Speak up for me.
Yes, Your Honor.
All right. And were charges filed against him for breaking and entering?
Yes, Your Honor.
So he's facing pending felony charges?
I believe so, Your Honor.
Okay. And have you received notice of any court dates on that?
Not yet, Your Honor. I was told it would be about 2 weeks before.
Okay. So Mr. Evans, part of that is I wanted to verify if there could in fact be pending criminal charges against you because that does impact how I would advise you to proceed today. Do you understand that?
Yes, sir.
So Mr. Evans, do you have a divorce attorney?
Yes, sir.
Who's your attorney?
It's Simpson.
Okay, and who's yours?
Matthew Raines.
Mr. Raines, okay, two very well experienced attorneys. So, Mr. Evans, you potentially could have criminal charges stemming from this. So anything you say today on the record could be used against you. So I would advise you at this point, your best interest would be served by pleading not guilty. And are you going to retain Mr. Simpson on this violation of the PPO?
Yes.
All right. Do you know when your next divorce pretrial is?
August 20th.
Okay, so I'm gonna set this out for another date, but Mr. Evans, understand, if there is another violation or allegation of a violation of the PPO, I can give you up to 93 days in jail for every violation.
Yes, sir.
So you will be sitting in jail for a long time, especially if there are pending charges. You may have a bond on that where you have to post to get out. Do you understand that? All right, so this is very, very serious. Okay, so those are the allegations against you. I'll enter a plea of not guilty on your behalf. I don't want you calling her. I don't want you driving by the house. I don't want you calling your mother. I don't want you to have any contact with your children unless it's through the divorce file. Do you understand that?
Just can I ask a question? We use the OFW app. And
App close?
It's the Only Family Wizard.
Yeah.
That's how I call the kids every day. Can I still do that? Because there's nothing in any of the files that's like I'm not supposed to see my kids or talk to them. I haven't been able to see him this whole time. So.
Yeah. Well, you know, you're saying things like the allegation and the text messages that I will walk inside and get the kids, fuck the legal stuff. I'm just asking you to answer. My concern is you're not going to honor the court's orders.
I will.
Because you're looking at a felony. Do you understand that? So I would advise that you call your attorney today and you call your attorney today. But I don't want at this time any contact even through our family wizard. So if there's going to be contact with the children, it's going to be some other way and your attorneys can make arrangements. But based on these violations, I don't even think our family wizard is appropriate at this time. Okay, because these are major serious violations of the PPO, especially with pending felony cases. So you are in a place where you gotta rein whatever is in, just so you don't lose everything, all right? Okay, so Ms. Adams, I would like to set this out to June 4 at my book. I think I gave you the book back. June 4 at 8 a.m. And ma'am, you can appear via Zoom. Do you understand that? You don't have to come in person. Do you have Zoom instructions?
I did not.
All right, Ms. Adams, I'm gonna need a notice of hearing for both parties and Zoom instructions for the petitioner in this file.
Okay.
All right, and you'll have to come in person, okay? So we're gonna set this over to June 4 at 8:30 in the morning. And you're gonna stay right here, actually, and then you're gonna stay right there for now. And we're gonna get you those notice of hearings, and then I'm gonna allow you to leave first, ma'am, and then I'm gonna have you wait 10 minutes, okay? But I mean, you already have a violation of this PPO.
When this day one, when it first happened.
Yeah. You're hiring Mr. Simpson on this?
Yes, ma'am. So he put in paperwork to be able to see my children. I just don't know.
No, on this PPO violation.
Oh, yes. So I hired him for the divorce and then for the PPO itself. He said 2 different cases. So I had him.
So, but he's not here today?
Not for the violation. Because I just hired him for the try to get it reduced so I could see the children. And I just got this on Monday.
Are you hiring him on this?
Yes.
All right, Ms. Adams, I'm gonna take that back. I want a sooner date. Can you connect with Mr. Simpson's office to see if he's available May 14?
Okay.
Hold on. Your Honor,
Mr. Malaro?
I have a William Feebig on my schedule. Is that on your docket? I didn't see it.
Say it again. Say it again.
A William Feebig is on my schedule, but I don't know if that's on your docket or not.
Did he say Fleabag? I can't understand.
Feebig.
I have William Powers, Christina Smith, Heimerdinger, I don't, Chris, I have a Charity Smith with you.
Yep, that's mine.
But
All right.
who did you say?
William Feebig.
Fleabag?
I was just about to say the first time I thought he said Fleabag. Vicky, welcome to the channel. Welcome and thank you for becoming a channel member. Other channel members out there, please welcome Vicky and thank her for joining us. Vicky, it's very much appreciated. It goes a long way. All of the money from channel memberships goes right back into the channel. I don't pocket any of that. It just goes into making what we do here better and better. So it's appreciated. Let's stick with Judge Anzalone here for a little bit longer.
I'll send her a message if you could give me a minute, Judge.
Yep, not a problem.
Judge,
Yeah.
Mr. Simpson is not available. We did work out May 22nd at 11:30 a.m.
All right, May 22nd, 11:30 a.m. So Ms. Adams, could I get a notice of hearing for both and Zoom instructions for Ms. Evans? I'm also gonna have Mr. Coast. You're employed.
Yes, ma'am.
My bailiff's gonna watch you for a minute. Don't go anywhere, all right? Be right back.
Man, just hang on. I don't know if the judge needs you to or not.
Oh,
Just-
I had to send her reverse, I'll check.
Oh, Link, my friend, there's a lot of criticism of the courts. Go read through the comments on any popular video on this channel. Just pick one and then go look, and there's criticisms all over the place. For all the criticism of the judicial system, judges themselves are very low on the list. Again, that depends. If you want a good example of judges who get criticized, go to everybody's favorite judge, Judge Fleischer. It seems like he's favorited because he's so polarizing. People love him or hate him, and those who bash on him bash hard. Let me tell you, it's kind of crazy. So I don't normally call it a day before 9 o'clock here on the West Coast, but I'm going to call it a day because, to be honest with you, there's just not a lot going on at the moment. Judge Anzalone just stepped away. I've got 5 other courts that I look at that are in recess, 2 that are doing trials. So there's just not a lot more to show you right now. It's been kind of a weird Wednesday, not only from a court standpoint, but from a stream standpoint here too. I just partway through the stream, my big board just stopped working. And then like 10 minutes later, it just came back. No reason. I have no idea. It's a weird day. But weird days can be good too. So let's go find a way, everybody, to have a good day. Vicky, again, thank you for becoming a channel member. Thank you to all of the channel members. Again, all of that money there just goes right back into making what we do here a little better every day, which is what we try to do. Yeah, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Hopefully there's a little more action for us to enjoy. If not, we always find something, and we'll have fun again. Again, everybody have a great day. Take care.